You did the responsible thing. You set up a living trust. You signed the documents, you paid the lawyer, you put the binder on the shelf and felt the relief of knowing your family was protected. But here's the part nobody told you. That trust may be completely empty, and an empty trust protects no one. In this video, I'll explain why a trust you never funded can fail your family entirely, even though you did everything you thought you were supposed to do. But by the end of this video, you'll learn exactly how to check whether your trust actually works and how to fix it before your family finds out the hard way. All right, let's dive into this one. I'm Santiago Cueto, board-certified international law expert and best-selling author based right here in Miami, Florida. Now, I've reviewed countless trusts over the last 30 years or so, and the most common problem isn't a bad document. It's a good document with nothing inside it. Well, let me explain what a trust actually is, because this is where everything goes wrong. A trust is like a vault. Signing the trust builds the vault. It does not put anything inside the vault. The only assets a trust controls are the assets you formally place into it. Everything else is sitting outside, completely beyond its reach. I call that an empty vault. The empty vault is a fully signed, perfectly drafted trust that owns absolutely nothing. On paper, it looks like a finished plan. In reality, it's a beautiful door with no house behind it. And here's the reason this happens so often. Building the vault feels like the finish line. It's actually the halfway point. The second half is called funding, and most people never do it. But it gets worse, because there's a backup document that gives people a false sense of safety. When your lawyer set up your trust, you almost certainly also signed something called a pour-over will. The name sounds reassuring. People assume it means anything they forgot just flows neatly into the trust. So they relax. Here's what a pour-over will actually does. It catches the assets you left outside the trust and pours them in after you die. That sounds great until you learn the route those assets have to travel. To get poured in, they first have to pass through probate, the exact court process you set up the trust to avoid. I call that the pour-over trap. You built a trust to keep your family out of probate. Then the unfunded assets drag them right back in through the very document that was supposed to be the safety net. Now you might be thinking, so the pour-over will is useless? Well, not at all. It's a backup, not a plan. A backstop you rely on as your main strategy will fail you, and that's exactly what an unfunded trust does. So what does it mean to fund a trust? Well, it comes down to one idea, and the title is destiny. Whoever holds title to an asset controls where it goes when you die. If the title says your trust, the trust controls it. If the title still says your personal name, the trust is irrelevant for that asset. Funding is the work of changing that title, asset by asset. Now, before I walk you through exactly what to retitle, hit that like button and subscribe to this channel. I cover Florida estate planning, trust, and asset protection every week, so your family is protected by a plan that actually works. Now let's fund the vault. Now start with real estate. Your home and any other property should be deeded into the trust where appropriate. This is the asset that sends most families into probate, and it's the one people most often forget to move. Next up, your bank account and brokerage accounts. These get retitled into the name of the trust, or in some cases, set up with the right beneficiary designations. Either way, the goal is the same. The account should not be sitting in your name alone when you die. Then, your business interests. If you own an LLC or a corporation, your ownership stake is an asset just like any other. It can be assigned to your trust so that the business doesn't get frozen in probate while your family waits for the court. Now here's the piece that trips up most everyone. Your beneficiary designations. Life insurance and retirement accounts do not pass through your will or your trust. They pass by designation. If those forms name the wrong person or an ex-spouse or no one at all, your trust cannot fix it. You have to update the forms directly. Here's what makes this so dangerous. An unfunded trust gives off no warning. Nothing breaks while you're alive. The binder sits on a shelf looking perfect for years. The failure only reveals itself after you're gone, in the worst possible moment, when your family is grieving and assume everything has been handled. That is the cruelty of the empty vault. It fails silently, and it fails at the exact moment your family was counting on it most. So the question is not whether you have a trust. The question is whether your trust owns anything. Pull out the binder, look at how your home is titled, look at your accounts, and if they're still in your personal name, your trust is a vault with absolutely nothing inside. All right, so let's bring this all home. Signing a trust builds the vault. Funding it is what fills the vault. A pour-over will is only a backstop, and relying on it sends your family straight into probate. Title is destiny, and funding is how you control it. The families whose trusts are funded glide past probate exactly as planned. The families whose trusts sit empty pay for a plan that never protected them. The difference is not the document. The difference is whether you finish the job. If this video made you want to go and check your own trust right now, well, that's the point. Hit that like button and subscribe to this channel so you never miss a new video. Share it with someone who has a trust binder collecting dust. And drop your questions in the comments below. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.